Page 3, continuing House Bills, third reading, regular House Bill 63, relates to criminal cases. Request for a jury to ascertain punishment.
Shall the bill pass?
Mr. Speaker.
The delegate from Blacksburg, Delegate Obenshain.
Mr. Speaker, I rise to speak to the bill.
The delegate has the floor.
Thank you, Mr. Speaker. Rise today to speak to House Bill 63. As I'm concerned about the direction that this bill would take us, Mr. Speaker, the object of our criminal justice system and particularly our criminal procedure, has been to place both parties on relative equal footing when it comes time for trial. Having been both a defense counsel and a prosecutor in my own career, I recognize the importance of this approach. We have laws that are designed to ensure that both sides have competent, zealous attorneys representing them to set the procedure for introducing evidence and producing witnesses, but we leave the tactical and the strategic decisions to the attorneys. That's why the point at which jeopardy attaches in a trial is so critical. That's the time that both sides spend so much time preparing for. Most of the major decisions about the conduct of the trial must be made before jeopardy attaches. The appropriate charges have to be in place, discovery shared, pretrial motions litigated, and witnesses secured. In fact, the government risks losing the entire case if they're not prepared at the point of jeopardy attaching. So it concerns me when I see a piece of legislation that appears to tilt the scales of justice in one direction or another. It's not our job as legislators to give a strategic advantage to one side over the other in a court of law. And that's what this bill would do. By allowing the accused to wait until not just the attachment of jeopardy, but in fact, until after the entire trial has been conducted and a verdict returned, to change his mind about how he wants to be sentenced. That most certainly provides the accused with a distinct strategic advantage. For what competent defense attorney wouldn't wait until the very last moment to make that decision if the option was available to him? What's even worse is that this bill makes the existing language, the 30-day notice requirement, almost completely superfluous. If the accused can change their election for jury sentencing at any point, even after a verdict has been returned, what's the point of providing advance notice of an election in advance of trial? It really becomes nothing more than a strategic head fake. And I would suggest that the appropriate point in a jury trial for that choice to be made is when jeopardy attaches, at the beginning, not at the end of the trial. Mr. Speaker, I believe this bill reaches too far in establishing not just trial procedure, but influencing trial strategy. I would ask the body to consider the long-term effects of placing ourselves in that position. I would ask the body to reject the bill.
The delegate from Fairfax, Delegate Simon.
Mr. Speaker, speaking to the bill.
The delegate has the floor.
Mr. Speaker, members of the House, I appreciate the concerns raised by the delegate. A couple things about that. Right now, the way that some judges are reading this statute, they're saying that that 30-day election is a final election. And so we talked about these different phases and when jeopardy attaches and when discovery and things are provided. I would note that discovery doesn't have to be provided 30 days out. You don't have to know the list of the Commonwealth's witnesses 30 days out, right? There are a whole bunch of things that happen much later than that 30-day election period. So one of the impetuses for bringing the bill was that you had to try and make this decision, this irrevocable decision about how to be sentenced before the defense counsel actually had a full understanding of what the trial was, what the evidence available against their client would be, what witnesses might be available to testify against their client, and so forth. And then the other thing that happens, and I spoke to this briefly the other day, is, back up for a second. The idea, I just want to say, the idea that the sides are sort of evenly matched. You know, that the Commonwealth itself doesn't have a tremendous strategic advantage and number of advantages in trial under our current system, I don't think is accurate, right? For instance, the Commonwealth has the opportunity to decide what to charge. They have the opportunity to extract guilty pleas from folks by saying, you're facing this mandatory minimum. We have a lot of mandatory minimums. One of the reasons some of us on this side don't love the mandatory minimums. Here's what I'm going to charge you with. And here's what it takes to convict you of that. And I may not have all of it, but if I do, and if the jury agrees with me, you have a mandatory minimum period of incarceration of 5 or 10 years, right? That may affect the decision about whether you want to be sentenced by the judge or by the jury. It may turn out that they didn't have the evidence to prove that, in fact, and you don't know that until the jury actually finds you guilty of a lesser included offense. And so at that point, your strategic decision about how you want to be sentenced would necessarily be different. So there's a lot of information that the government has early. They don't always disclose it on time. A lot of information the defense will not be able to have until that verdict is rendered. It is absolutely essential to making an informed decision about what form of sentencing you'd like to have. Mr. Speaker, members of the House, I appreciate the concerns. I think this actually does what the delegate says we ought to be doing, which is to even the playing field, to even things out in a situation where currently the government has such a tremendous advantage. And let's defense counsel and defendants have a fair shot at getting equal justice. I hope it'll be the pleasure of the body to pass the bill. Thank you, Mr. Speaker.
Shall the bill pass? The clerk will close the roll.
Ayes 53, noes 42.
Ayes 53, noes 42. The bill passes.